Hello and welcome. I'm Professor Rashmi Raman and this is Module 11, Genocide Part 1. In the past 150 years, millions of people have been murdered, raped and tortured, among other heinous crimes, which fall under the current category of genocide. Historic acts of genocide should remind us of what is at stake if we allow genocide to occur again. Two most significant cases of genocide that brought about the rise in collective consciousness to criminalize that act are the Armenian genocide and what is known as the Holocaust of 1940. These two atrocities have reminded the world of the horror faced and the change required to extinguish this evil. Genocide is a crime of grave nature, which involves an egregious violation of human rights. The dire need for a codified law preventing and punishing genocide arose from the ashes of the Holocaust. The word genocide comes from two words, geno meaning race and cide meaning murder. The term was originally coined by a lawyer named Raphael Lemkin in 1944 in his book entitled The Axis Rule in Occupied Europe. He defined genocide as a coordinate strategy to destroy a group of people, a process that could be accomplished through total annihilation as well as strategies that eliminate key elements of the group's basic existence, including language, culture, and economic infrastructure. Lemkin was one of the driving forces behind the codification of the Convention on the Prevention and Punishment of the Crime of Genocide. This convention was introduced and passed at the United Nations General Assembly. By General Assembly Resolution 260A of 9th December 1948, the convention was approved and proposed for signature and ratification or accession. It formally came into force only on the 12th of January 1951. Let us now talk about defining genocide. Genocide, according to the convention, is mass murder that is deliberately committed by an individual or a group of individuals with the intent to harm or get rid of a national, ethnic, racial or religious group. Although it was only formally recognized in 1948, the act of genocide has been seen by generations. The recognition and criminalization of this offense has been a significant one, reminding us of the criminalization of apartheid. Recognizing genocide as an international crime made it a part of international law, where all states accepted the criminalization of the act and also partook in the responsibility to reasonably stop this act if and when possible. Genocide as a part of customary international law and jus cogens, however, preceded the codification of genocide as a treaty. In the case of the prosecutor versus Clement Kayishema and Obed Ruzindana, in paragraph 88, the ICTR laid down in the trial chamber that, quote, the crime of genocide is considered part of international customary law and moreover violation of a norm of jus cogens, close quote. The same definition was also repeated in prosecutor versus Rutaganda in paragraph 46, that the Genocide Convention is undeniably considered a part of customary international law. What does this mean? It means that violation of this rule is a violation of a norm. Let us now look at the Armenian genocide and the Holocaust. In 1915, the Ottoman Empire systematically destroyed 1.5 million Armenians in an attempt to form a new empire united by one language and one religion. The Armenians were rounded up, tortured, hanged or shot on orders of the government. Women and children were mercilessly slaughtered. This case of genocide highlights the problem of sovereignty. Should the redressal of the crime be in the hands of the nation where it was perpetrated, or should the international community be the one to intervene? When the state itself is committing the crime, there is no possibility of the state bringing the perpetrators to justice or convicting them at the domestic level. And therefore, at least in the short term, when a state perpetrates genocide, it calls for the need to have an intervention on humanitarian ground and use of universal jurisdiction. Being a crime committed with a criminal intention to destroy a human group, and due to its very nature of being a distinctly heinous category of crime against humanity, which comprises a series of coordinate actions aimed at the destruction of the foundations of life of various national, ethnic, religious, and racial groups, so as to completely annihilate them. It has to be governed under the principles of international criminal law. As stated by Lemkin when he coined the definition in 1944, genocide is the crime of destroying an identity, that is, national, racial, religious, or ethnic groups. The problem now arises as to whether it is a crime of only national importance or a crime in which international society as such should be vitally interested. It would be irrational to treat genocide as a national crime, since by its very nature it is committed by the state or by peaceful groups which have the backing of the state or the support of the state, as happened in Rwanda in 1993, 94, and 95. The Convention on the Prevention and Punishment of the Act of Genocide was brought about in response to the mass atrocities of the Nazi regime. The regime was led by Adolf Hitler, who was obsessed with the idea of the superiority of the Aryan race. In 1934, Hitler appointed himself and anointed himself as Führer, making him Germany's supreme ruler. The Nazi ideology dismissed non-Aryans and persecuted them. Hundreds and thousands of Jews and Gypsies were stripped of their identities, occupations, and were forced to live in concentration camps, where they were tortured and killed. The Jews in particular were not the only ones that were persecuted by the Nazis. Thousands and thousands of handicapped people and Polish people were treated similarly, as were homeless people and the Gypsy. The Holocaust, as it came to be known, was a mass killing of Jews, Poles, Gypsies. They were killed, and it depicts premeditation and deliberation and a systemic criminality, which is indeed an aggravated circumstance for imposing punishment upon the perpetrators. After the Second World War, the international community recognized the need to codify and recognize the prevention of these atrocities. The United Nations General Assembly adopted the United Nations Convention for the Prevention and Punishment of the Act of Genocide. At the time of coming into force, this convention was signed by 41 parties that were founding parties and had 146 states participating. The convention defines genocide and the actions that constitute the act of genocide, giving it a legal definition that is universally accepted. The signature to the convention confers upon the signing state duties that entail that state to enact legislations that punish genocide in its own territory and that do not allow for the legal defense of acting in official capacity. This is known as ratification, bringing into force in municipal law. States must also take measures to reasonably ascertain the location of an accused within the state's own border and arrest them. The state must also cooperate with extradition requirements by treaty or by customary international law. I would now like to discuss the role of the United Nations. The universally accepted definition of genocide is a precise category of crime. It fails to include political and social groups. For an act to come under the term genocide, it must have an intent to destroy. The United Nations failed in the beginning to recognize other crimes of similar magnitude as genocide based purely on the difference of intent. Crimes of ethnic cleansing, for example, do not fall under the umbrella of genocide because of its narrow definition under the 1945 Convention. Due to this lacuna, the killing fields in Cambodia would not amount to genocide because the objective criteria behind the Khmer Rouge's intention was to eliminate the possible political opponents and not eradicate the Khmer people as such. Therefore, the intent was not there. The purpose of bringing about this convention was to prevent genocide from recurring. But for this objective to succeed, it became extremely important to broaden the definition of genocide to include acts that cause genocide and acts that form the basis for the spread of genocidal intent. The approach of the United Nations then moved from interventions based on proof of intent to predicting and preventing at an early stage such elements as constitute proof of intent. To ensure the prevention of genocide, it is crucial to understand the issues that eventually led to genocide or that lead to genocide. Significantly, issues such as racism, intolerance of a particular group of people are acts that form the base for the idea of genocide to then be nidated in a community. Agitation directed at particular groups must be looked at seriously. Looking into past actions that led to genocide and symptoms in the present could be one of the ways that genocide may be prevented. Genocides in Rwanda and Darfur, for example, are instances where the genocide could have been prevented had the international community demonstrated a strong and unanimous political will to deploy their forces and to impose strong boycotts and no-flight zones. Similarly, in Bosnia and Serbia, had it not been for the lack of political will and the proper instruments at the disposal of the United Nations, an intervention at an early stage wherein ethnic cleansing was undertaken by the Serbs could have stemmed the genocide, and this could have been prevented. In order to adopt preventive strategies and preventive measures against genocide, there is an important need to have an independent United Nations genocide force, which is answerable only to the United Nations and not to member states. In addition to this, perhaps a genocide watch advisory board could be set up under the authority of the Secretary General of the United Nations, who has special powers under Articles 99 and 100 of the Charter. This force could work in association with various transnational groups such as Human Rights Watch, Amnesty International, so as to give a detailed early warning signals and identify the inchoate signs of genocide, and also to monitor conflict situations so that they do not escalate into a full-blown genocide. It is clear that there exists a certain kind of frustration with the limit that this puts on the ability of international law to deal with atrocities and crimes. For example, how ethnic cleansing cannot yet be included within the ambit of the Genocide Convention was confirmed by the ICTY's restrictive approach to it. Ethnic cleansing and genocide are very closely related, but the narrow definition of genocide excludes other crimes such as deportation, torture, rape, and other inhumane acts intentionally causing suffering or serious bodily or mental injury. Based on the universal definition created by the Genocide Convention, genocide now emerges as a precise category of crime, where the most important element is the intention to destroy, whereas ethnic cleansing, as it is defined in the Oxford Handbook, is not necessarily aimed at destroying the group, but forced removal of ethnic or related groups from a particular geographical area. Whereas this falls under other categories of international crime, what I'm trying to emphasize here is that the Convention on the Prevention and Punishment of the Crime of Genocide is restrictive. This convention recognizes that at all periods of history, genocide has inflicted great losses on humanity and has been said to be one of humanity's most odious scourges. The convention, with its 146 initial parties and 41 founding signatories, defines the act of genocide and also criminalizes it. It also criminalizes certain acts committed with the intent to destroy, in whole or in part, a group as previously defined, national, ethnic, racial or religious. Killing of members of such a group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, in whole or in part, and also imposing measures intended to prevent births within the group. And finally, forcibly transferring children of the group to another group. All of these are part of the definition of genocide in the convention. However, the convention doesn't talk about the existing laws of genocide that existed within customary international law. Under the convention, Article 3 defines what crimes can be punished under the convention. Apart from genocide, it also talks about conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, complicity in genocide. For an act to be considered genocide, the following objective principles must be present. 1. Deliberately committing an act to destroy or aimed at destroying a large number of people in a particular community or in a particular geographic area. What is the intent to destroy? It requires a degree of knowledge of the ultimate order or act. It was only on September 2nd, 1998 that the world saw the first conviction for the crime of genocide. The International Criminal Tribunal for Rwanda convicted Jean-Paul Akayesu for his acts as mayor of the Rwandan town of Taba. However, recent decisions of both the tribunals, the ICTR and the ICTY, have understandably, but perhaps erroneously, determined that complicity in genocide is merely a form of liability for the crime of genocide and not a crime in and of itself. These decisions incorrectly apply the heightened requirement of intention of the one who aids and abets the crime of genocide onto the one who commits the crime of complicity in genocide. Let us talk about some of the key features of the convention and the features that make genocide a punishable crime, whether committed during peacetime or war, and contracting states which have to take every measure to prevent and punish the crime. For example, Article 3 of the Convention punishes separately attempt, conspiracy, complicity, incitement to commit genocide, as well as genocide itself. The contracting states also have to ensure that they have legislations within their national legal system to give effect to this convention. As I explained before, this is an act of bringing force nationally to international law. A person accused under the Genocide Convention is to be tried by a competent court or tribunal, and the due process of law will be available to them. What is the meaning of the term intent to destroy? This term appears in Article 2 of the Convention and has been cause of some judicial concern about whether it ought to be interpreted in a broad sense or in a narrow sense. In the judgment given by the European Court of Human Rights in Jorgik versus Germany in 2007, the court highlighted all the approaches taken by the tribunals thus far. A narrow view would mean that the intent to destroy means intended physical and biological destruction of the protected group, and the majority in the Jorgic case upheld the narrow view. A broader view would mean that physical and biological destruction was not necessary as the intent to destroy a national, racial, ethnic or religious group to qualify as genocide. The court also noted that the International Criminal Tribunal for the former Yugoslavia and even the International Court of Justice agreed with the narrow view and interpreted the narrow view to hold that an intent to destroy must be found stricto sensu. The ICTY has held the same in Prosecutor versus Kupreskic and others, wherein the court defined the distinction between genocide and persecution. And the court says, quote, "Persecution is only one step away from genocide," close quote, the most abhorrent crime against humanity. For in genocide, the persecutory intent is pushed to its ultimate limits through the pursuit of the physical annihilation of the group or members of the group. In defining the crime of genocide, the criminal intention is to destroy the group or its members. In the crime of persecution, however, the criminal intention is instead to forcibly discriminate against a group or members thereof by grossly and systematically violating their fundamental human rights. However, it stops short of annihilating them. Along the same lines, the International Court of Justice in the celebrated Bosnia and Herzegovina versus Serbia and Montenegro case also laid down the following, quote, "Neither the intent as a matter of policy to render an area ethnically homogeneous nor the operations that may be carried out to implement such policy can as such be designated as genocide," closed quote. The intent that characterizes genocide is to destroy, in whole or in part, a particular group. Deportation or displacement of the members of the group, even if it is effected by force, is not necessarily equivalent to the destruction or annihilation of that group, nor is such destruction or annihilation an automatic consequence of displacement. This is not to say that the acts described as ethnic cleansing may never constitute genocide, or that they are not serious enough to constitute genocide. If they are as such to be characterized, for example, as deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, in whole or in part, contrary to Article 2, Paragraph C of the Convention, provided that such action is carried out with the necessary specific intent known as dolus specialis, that is to say, with a view to the destruction of the group or the distinct removal of the group from the region. In such cases, persecution could qualify as genocide. The ICTY has observed, quote, "While there are obvious similarities between genocidal policy and the policy commonly known as ethnic cleansing," close quote, in the case of Kristic, ICTY trial chamber decision of August 2001, a clear distinction must be drawn between physical destruction and dissolution of a group. The expulsion of a group or part of a group does not in itself suffice for the crime of genocide. Let us now talk about the meaning of in whole or in part. The case law for this is Prosecutor versus Radislav Kristic, in which the ICTY was required to interpret the term in part. The court said that there was no set standard by which one might interpret in part. The Convention too is silent on any form of indication of what in whole or in part meant. Early commentaries on the Convention opined that the matter of what was substantial fell within the ambit of the judge's discretionary evaluation. Legal scholars have also widely commented on this issue. Robinson was of the view that the intent to destroy could pertain to only a region or even a local community if a number of persons targeted was substantial, and that is what in part meant. Drost remarked that any systematic destruction of a fraction of a protected group constituted genocidal intent in part. The International Criminal Tribunal for Rwanda, in the famous cases of Kayishema and Ruzindana, in paragraph 97 of Ruzindana, stated that the intent to destroy a part of a group must affect, quote, a considerable number, close quote, of individuals. The same position was also reflected in Prosecutor versus Bagili Shema, where in paragraph 64, the court held that although the destruction sought need not be directed at every member of the targeted group, the chamber considers that the intention to destroy must target at least a substantial part of the group. The ICTY also referred to other sources to understand the meaning of in whole or in part. It noted that Benjamin Whittaker's 1985 study on the prevention and punishment of the crime of genocide opines that partial destruction of a group merits the characterization of genocide when it concerns a large portion of the entire group or a significant section of that group. In part would seem therefore to imply a reasonably significant number relative to the total of the group as a whole, or else a significant section of a group such as its leadership. The final report of the Commission of Experts, established pursuant to the Security Council's Resolution 780 of 1992, confirmed the interpretation that I have just explained. It considered that an intent to destroy a specific part of a group, such as its political, administrative, intellectual, or business leadership, may be a strong indicator of genocidal intent, regardless of the actual numbers killed. The report concluded by stating that in part means seeking to destroy a distinct part of the group as opposed to an accumulation of isolated individuals within the group. Thank you.